Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Okay, I'm looking for, I'm calling, I should say, case number 14-102412. This is Catch LLC versus Benson Bryant. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that the writ of garnishment issued as a result of the entry of a judgment. That judgment was entered on the 20th of June of 2014 for $2,034.75. It also appears that that judgment was renewed on May 1st, 2024. All right, your appearance, counsel, regarding this matter, please.
Good morning, Your Honor. Attorney Ashley Nonis Hartman on behalf of plaintiff.
All right, thank you, Ms. Hartman. Good morning to you. I'm looking for Benson Bryant now, please.
Good morning, Your Honor.
All right, good morning to you, Mr. Bryant. All right, so I'm looking, and it looks like you indicated that the writ should not be allowed because you have no knowledge of this debt. Tell me about that, sir.
Well, Your Honor, when I first, I just figuring out when I first called the plaintiff, and these calls were recorded as they do tell you when you're calling them.
Wait a minute. You need one of them jobs or something where you can talk all day to tell me a short subject. You filed objection. Your objection says that you have no knowledge of this debt. Is that what you're telling me? That's why you object, because you don't know anything about this debt? Yes or no?
Right. So yes, sir. So long story short, this was a credit.
Let me stop you for a moment, because I'm looking at a register of action that shows that there were multiple times where there was a garnishment issue against you for income taxes and what have you over the years. So how are you saying that you don't know anything about this debt?
And that's what I was trying to explain. When I said knowledge of the debt, what I'm claiming is there was identity theft. I did not open up any credit cards in 2014. I was actually a full-time student in college, no job or anything of the matter. When I first got my income taxes held in 2018, I called the IRS and nobody could give me any knowledge as to why or who it was or what it was for. And I got the runaround pretty much. When I got into contact with Catch LLC and just recently, which again was on recorded time, they told me they had no knowledge of what the debt is exactly for. It was either a health card, it could have been a credit card. They had no exact placement as to where the debt came from. So that is why I'm filing that motion of objection. Also, they told me that they sent it to the address that they had on file. I had not lived there for over 8 years.
All right. Madam Counsel.
Thanks, Judge. So first and foremost, the objection is invalid under MCR 3.101. He's attacking the judgment, which is not proper for an objection to garnishment. Second of all, The judgment looks like it was served to his current address of record. As you stated, the motion was renewed. There's been several garnishments since the date of judgment that put the defendant on notice. Both the years 20 and 21 yielding funds. The defendant contacted our office in 2020 when he was informed about the debt. At that time, he said he was going to reach out to the court to get more information. He called back to our office in April of 2024, obviously regarding this tax garnishment. So the defendant has been well aware of this debt for at least the past 4 years. He's done nothing to do it, to pay it, to contest it, nothing. So to say he doesn't have knowledge of it and thinks that it's fraud, it's just at this point a moot and irrelevant, stating it's invalid under the law, so his objection is required to be denied.
Once again, Your Honor, like I was saying, when I called you, which I just stated that I called multiple times, there was never any indication telling me where exactly this debt was coming from. There was never any indication showing exactly what the debt was from until I went down to the courts today. Oh, I'm sorry, not today, this year. And I had to pay for the actual file to get that. Now, I do acknowledge that I did essentially give up on figuring it out in 2020 because I was getting the runaround. However, that does not take away from the fact that none of this debt was in my name, or sorry, none of this debt was actually of my doing. I haven't seen a wet signature. I haven't seen any type of actual documentation showing that that was actually me. The address that she said she has on file, I would like to hear that.
We're arguing the case.
Ms. Ellis, Ms. Hartman, don't interrupt, ma'am. All right. So, I mean, listen, here's the issue. You have two aspects of the case. And it's difficult sometimes to address matters because obviously things that lawyers know are things that are required on the part of people who are not lawyers. They're held to the same requirements. And that is that when you file objecting to a writ of garnishment, the only issues that you can raise on that garnishment are what's called post-judgment issues. That means that it has to be an issue like I filed bankruptcy, or I'm under a partial payment plan, or I already paid this debt off. That's the only thing you can do. Only those kind of issues are the issues that you can raise when you are filing to try and defeat a garnishment. The other issues are what's called pre-judgment issues. That means that if it is something that has to do with prejudgment, you're saying that the judgment never should have. You're saying the judgment never should have been entered, and I'm objecting to it because the judgment never should have been entered. Well, you have to file a different type of motion to try and do that. That's a motion to try to get the judgment set aside. As long as that judgment is in place, you only have a limited amount of objections that you can raise, because what you're attacking is you can only attack the garnishment, that they're garnishing me, but I already paid them. They're garnishing me, but I filed bankruptcy, so they can't garnish me. They're garnishing me, but I received Social Security, so they can't garnish my Social Security. What you're arguing today is that the judgment shouldn't have been in. Way back in 2014 or whatever it was, the judgment should not have been in. You can't raise that in a post-judgment hearing. You can file a motion to try to get that set aside. The reason that I took time to listen to you is to see whether there was anything reasonably that you could raise that might get that judgment set aside at some point. And I haven't heard anything because for a couple of reasons. One is the file shows that there was proper service that occurred back in 2014. But more important than that, whatever year it was, more important than that, you've known about this for at least 4 years. And while you may have contacted the creditor, you never filed anything in court. Court is where this case is now. That's why you see the creditor here, and that's why you see yourself here. This case is in court. You don't resolve a court case by going to the other side. You file something in court. The reason that you have a hearing today is because you filed something in court, not because you talked to their office. in 2020 or whatever it was, if you wanted to try to get the judgment set aside, and you say that's the first time that you heard of it, although the register of action shows that you would have known about this sooner than that. At the first point that you found out about this, you would have needed to file a motion to try and get that judgment set aside. And I know you didn't know that because you're not a lawyer, but you're required to know that. You're required to find that out. If somebody sues you, you got to find out what you need to do. If a judgment is entered against you, you got to find out what you need to do. And if you don't take action, you lose certain rights. And so I took a moment to talk about this because from the outset, there's really nothing to talk about on the garnishment. There's nothing to talk about. There's a judgment against you. There is a garnishment. And what you want to do is you want to raise issues about, well, this is fraud. It shouldn't have been entered against me. Well, you should have raised that at least 4 years ago, probably 10 years ago. And you still have the right under law to raise it if you wish to, but you have to raise that in a different type of motion. You can't bring pre-judgment issues into post-judgment issues. Garnishment is a post-judgment issue. It means there's already a judgment. You can't come to this hearing and say, Judge, that judgment should be entered against me. The law does not allow me to consider that. Now, I know that nothing that I tell you is going to be helpful in that regard, but I promise you that the law does not allow me to consider the issues that you're raising because this is a post-judgment matter. It doesn't allow. That's why Ms. Hartman almost got on my last nerve because she said, Judge, you have to do this. You have to do it. Judges don't like to be told what they have to do, but I know what the law says, and she knows what the law says. She could have been a whole lot more delicate and said, well, Judge, based upon the law, it probably is something that you're going to have to rule a certain way on. She's absolutely right. She's absolutely right. The law does not allow me to consider your pre-judgment matters. This is a garnishment matter. Now, I've said it about 3 or 4 times. That probably gives you a bit of a tip-off. If you think that you want to challenge this case based upon the judgment, you have some things that you can do. You probably waited a long time, and it may be too long. But if you wish to file a motion to set aside default, for example, you can always file something like that. But you can't raise that in a garnishment hearing. You simply cannot do that. All right. So the objections to what is it, sir?
I just had one question. First off, thank you for the intel. But in the case of figuring out, because in 2014, like I said, I was not served because I was not at that address. And
okay,
like I said, let me stop.
None of that means anything. None of that means anything.
All right.
I promise you it don't. Now,
okay.
If you take a deep breath and think about the instruction I've given you, you understand why I'm not going to let you tell me about anything that happened regarding the judgment, because that's not before me. That's just not before me. I've taken more time on your case to try to address that because I want you to understand it, because maybe you want to file a motion. It's probably too late, but maybe you want to do that. The problem that you have now is that there is a judgment that has been in place for a long time, and you need to find a way to manage paying that, cutting some kind of deal to try and get it resolved, because it's not going away because you waited. It seems to me that you waited too long to react to the judgment. I'm not talking about the garnishment part. The garnishment part, you can say that, hey, I filed bankruptcy and you can get rid of the garnishment by doing that. But without something like that, there is no, the objections that you raise are simply not valid objections. They're not objections that I can even take into consideration, right? So I will find that the objections are invalid, and the funds withheld be released to the plaintiff. Now, let me ask you this: is this garnishment as against your job? Is this where you work?
That's correct.
All right. How much is being taken from you on a per pay period?
Enough to affect my means of living and provide for my family. Well,
that's okay. Don't tell me, okay? And I'll leave it completely in place.
I honestly do not know. When I asked them exactly how much was being taken up, I'm saying
I'm gonna stop. Here's what you do: file a motion for installment payments to try and get the amounts reduced that are being taken from you. I tried to get specific answers from you so that maybe I could have brought you to a place today where you could come up with a payment plan that reduces the garnishment amount. But you can't figure out what they take from you, whether it's $1 a pay period, 500, 200, 350, between 200 and 250. You have no idea what is being garnished from you. If I had that information, then maybe I could bring you to a place where we could reduce that. But you don't want to talk to me. I've stayed on your case longer than anybody else's case today. So what you do is file your petition for installment payments, and then you'll wait a couple of weeks and a decision will be made on your installment order. So you know, if you listen, if you listen, that's why you have the 2 years. If you listen, then maybe you can make some progress. I'm trying to help you make progress. I know that I take a moment sometimes because I see young people and I see people that I know don't understand the law as well. And I don't have to do any of that, but I take time to try to gradually walk you through it, that maybe you can make some choices that will be helpful to you. If I can't get answers to questions, then I knew to help you along that pathway. So I'm done with this case. The garnishment stays in place, but you do have the right to file a petition for installment payments. I wish you well. Good day. I'm going on to the next case. Thank you, counsel. Thank you, sir. All right, this is case number 17-100514.
Your Honor, Your Honor, I'm sorry.
No,